My name is Darren Joseph from HTJ.tax, and we're the team that seeks to demystify the sometimes confusing world of international tax. And today we have the honor and privilege of having another conversation with Mark. Mark, could you introduce yourself?
I'm an advisor to the entire financial industry on CRS, FATCA, and CARF, and I've advised the OECD and the EU Parliament and the EU Commission and the German government, etc. All this is on my website for anybody to look at.
Fantastic. So today we want to focus on UK trusts and UK underlying companies when it comes to wealth management, and especially now when we're spoiled for choice. There's so many jurisdictions all over the world. Let's talk about what is a non-UK trust. What is the definition of a non-UK trust, Mark?
Okay, so this terminology, even I got confused for a long time, and I still see, as recent as yesterday, people writing about non-UK trusts, and they inadvertently or mistakenly refer to non-UK trusts when there are non-resident trusts, UK non-resident. A non-UK trust, which makes sense, is a trust where the settlor has chosen the governing law of the trust to be any other jurisdiction except for the UK. It doesn't matter where the trustees, beneficiaries, settlor, protector is. If you're living in the UK and you're a settlor and you choose the BVI or Guernsey, then it's a non-UK trust. The question is, if you're going to choose a proper law of another country, should you choose one that a jurisdiction that recognizes trust? And the Hague Convention says you should. And to be certain of selecting a country that recognizes trust, rather than just Googling it or using AI, look at the 14 signatories in the Hague Convention, 1985, on the recognition of trust. So there's only 14. And, so if you want to choose a non-UK trust, then make sure you choose one of the 14. There are countries such as Canada, except for Quebec, Italy. So there's some common law countries that recognize trust, Switzerland being one, Netherlands, and the Netherlands European territories only, San Marino, etc. Okay. And of course, the UK territories, etc.
What if you choose a jurisdiction that does recognize trust but is not a member of the Hague Convention? They didn't sign.
You could run into problems if somebody contends that, some creditor going after you there and saying like Spain doesn't recognize trust and therefore you still own the assets. They don't recognize that you gave it away, the assets. They don't recognize the distinction between legal ownership and beneficial ownership. And you're going to land up with problems in legal cases.
Okay. All right.
Thank you very much again for sharing your incredible insight. What's the best way for someone to find you or to reach out to you to get in contact?
My website, co-ownershiptrust.com, and then you'll find 850 articles.